Good afternoon. I would like, first of all, to thank the International Association of Judicial Officers for inviting me to participate in the Congress and the team chosen for it, Cyber Justice. And I mean that in our panel, the discussion would be in the seizure of the digital assets. What can we do, and what the regulatory and national authorities of different countries can do and can contribute to make it more efficient. I think the balance between the creditor's right to a fair enforcement in a reasonable time, which is also stated in Article 6 of the European Convention of Human Rights, and the fundamental rights of the debtor to a fair trial, to be heard about the procedures, and to the private property of his assets and the protection of his liberty, of his security, of his protection of his private life and private assets, of course, is an issue, and this balance must be think about it in a reasonable way. And I think the criteria of decision is the right to a fair trial, or the due process of law, that must sort the positions of these conflicting interests and rights of the parts. And in order to do that, I think we have to put in our legal system some boundaries. I mean, in Portugal, that will be absolutely impossible to have some measures like the ban on leaving the territory, the country, or the suspension of the driving license, let alone the prison, because that will violate our constitutional rights that are in the Portuguese constitution, fundamental law. So what we do in the civil enforcement procedures is that we don't ask anything to the debtors, which respect his fundamental rights, but we go on the side and we give them the powers to investigate, and not only the identification and the location of the debtors and his assets, but using mainly or exclusive electronic means, the communication and information technologies. And we give that powers to the enforcement agent, for example, having access to the databases of the Ministry of Justice, of the Ministry of Finance and Social Security, to see the databases of the civil, land, commercial and automobile registers, of the tax administration registers and the Social Security registers, and also to enforce the seizure and to obtain the electronic seizure of bank accounts. What we do within the seizure of bank accounts is that the enforcement agents has electronic communication access direct to the and asks the financial regulatory national authorities regarding the credit institution, that is to say the Banco de Portugal. So I think the main thing is that this is going on very well. Our system of cyber justice is very efficient. So I think the main issues now is that if we have a system where that works without the collaboration of the enforcement of the debtors, and that relies on this electronic communication with the enforcement agents, with all other authorities, maybe the seizure of digital assets, especially bitcoins, the digital wallets, and other sophisticated means by which the debtor tries to hide his assets, we could discuss the role of the Autoridade Nacional de Comunicações, ANACOM, which is the regulatory national authority for communications, both electronic and postal, and the space activities, in order to have the enforcement agents asking ANACOM about the digital assets and stored in digital platforms in this sophisticated digital area. Or maybe ANACOM and other regulatory authorities could launch a digital regulation cooperation platform, as the Dutch regulators did it in order to strengthen the oversight of digital activities. And that would be very important because nowadays also the systems of artificial intelligence and machine learning, we are used to do it at ANACOM, not only to the consumer complaint system, but also we are trying to modernize our administrative system regarding the activities of the oversight activities and supervision activities and the sanction area, so that we can have the electronic interconnection with the Portuguese courts. And we have recently have a very interesting meeting with the Lisbon court, judicial courts, and with some judicial officers and judges in order to learn how the electronic system in the courts, CITIUS, it's his name, has helped the judicial system in order to have this efficiency also within ANACOM. And this is very important because I believe this transformation will have very results not only in the supervision processes, in the administrative proceedings, and also in the relationship between ANACOM and regulated companies, operators, manufacturers, users, single citizens, the courts, and other public and private entities. I believe this is a fundamental path that we have to do in order to have a better public service, and the faster sentencing decisions influences the market and the performance of communication operators. And this will also increase the protection of consumers' rights, which is one of the main goals of our activity. And I think this cyber justice applied to ANACOM or other regulatory authorities is going to be the cornerstone of the debate around the new regulatory changes in this digital age. And it will also, of course, will ensure the contribution for a better public service. I wish you all good health and a good Congress.